Okay, well, good afternoon, everyone, and welcome to today's webinar on You've Got to Roll With It, an autumn immigration law update with Adam Pipe from No.8 Chambers. As you may know, my name is David, and I'm the founder of DG Legal. Most of you have been regulars, and you'll be familiar with the fact that we always send the slides from the presentations over to you, and that will happen tomorrow. And a recording of the webinar will also be available for a period of 3 months. So if we do run over, because there is quite a lot to cover and you need to leave, you'll be able to watch the rest another time. Now, we are in webinar mode, so we can't see or hear any of you. By all means, you can use the chat function to say hello to each other. I don't think we're going to have time for questions. I may be wrong, but there's so much to cover that this may be an exception to the rule where we don't cover questions, but let's see how we get on. You've probably heard Adam speak before. He's an absolute legend. He's hugely experienced in all aspects of immigration and asylum law, particularly interested in refugee law. He's appeared at all levels of the Asylum and Immigration Tribunal, and of course in the Admin Court and the Court of Appeal. His caseload, which is very varied, includes country guidance, indefinite leave to remain claims, and sponsorship license revocations for claimants. He's quoted, people have quoted him as saying that he gets to the point and is well respected by court judges who respect his knowledge and abilities. By the way, this is our 195th free webinar since we started in 2000, and we've had 74,500 bookings. And I think on this particular one, I think we're at around about 800 bookings, which is absolutely amazing. So without further ado, over to you, Adam.
David, thank you very much. And thank you for that kind introduction. Well, welcome everybody. And it's always fantastic to have so many people sign up to the update. And you'll see my title is nicked from EUSS. EUSS concerts are the hottest thing around at the moment. Well, hopefully this is a hot topic for immigration lawyers because we've got to roll with it because there are so many changes to immigration law. So today I'm going to give you some of the key changes in terms of practice and procedure, the immigration rules and case law. As David said, the slides will be available along with a recording of this so you can have a look at it later. Thank you so much for DG Legal for putting these events on and for providing them for free. It's such a resource to the legal profession. If you are interested in getting authorization to open a law firm, getting Lexel accreditation, compliance with GDPR, handling complaints, increasing your clients, do contact David and the team at DG Legal, who can give you professional consultancy services in relation to that. For those of you who want my free resources, grab your phone out now and do scan this QR code. The other thing this QR code will do is take you for a link for my next upcoming live in-person update. I'm doing that at the beginning, I think the 3rd of December. And I'm really conscious, as David has said, there's a lot to go through today. So if you've got questions, if you want to discuss these issues in greater detail, do sign up for my live in-person event when we've got a whole afternoon to work through these things together. Or if you just want some of the free resources, scan that QR code. Finally, the link for this webinar, which is at the bottom of my slide, and it's the link where the slides will be available and the video will be available, contains some links to DG's chosen charities, and they are available, even though this webinar is provided for free, because there's hundreds of us signed up. I'd encourage you, donate a few quid to those charities because we can make a real difference in the world. Right, let's get going. Hopefully, let's give you some positive good news, especially for those of you who may have stayed up watching election results from across the pond overnight. Let's have a look at some of the latest news and developments. The first thing is the Illegal Migration Act 2023 Amendment Regulations 2024. This was brought in by the Labour government as a way of being able to process all those asylum claims and people being able to be granted leave and ultimately citizenship, regardless of when they arrived in the United Kingdom, because a large cohort of those had been declared inadmissible. They were earmarked under the Rwanda scheme, which is now gone, thankfully. So this amendment to the Illegal Migration Act allows for those claims to be processed in the United Kingdom. So those cases previously declared inadmissible should now be dealt with. We should be getting those decisions, and those appeals should be working their way through the system, obviously subject to large tribunal backlogs at the moment. I noticed online in Parliament this question about Ukraine, just something to earmark coming up, that the government are introducing a bespoke Ukraine permission extension due to open in early 2025. And this will allow people under the Ukraine schemes to apply for further permission to remain in the United Kingdom. And to allow ease of transition, this scheme will open in advance of the first Ukraine scheme visas expiring. Obviously, I don't think it's a route that will lead to settlement, because one thing they point out here is the Ukrainian government have been clear about their strong desire for the future return of its citizens to help rebuild Ukraine when it is safe to do so. It is important that our approach respects these wishes, but watch out for the Ukraine permission extension, which may affect some of your clients. Now, one of the other things I wanted to point out was the changes to the visa application services, and in terms of commercial partners. The commercial partners for applications outside the United Kingdom are changing in some regions between September just gone and January next year, changing from TLS Contact to VFS Global. The individual locations that are affected are listed in the guidance. And in terms of applications inside the United Kingdom, the commercial partner is changing or has changed from the 15th of October from Sopra Steria to TLS Contact. The issue that we've been encountering is that the limited availability of appointments in country. So that's just something to be aware of. Now, previously, I've done a video with Amy Higgins from DG Legal, and Amy's also produced a free advice note on the SRA. They've had a thematic review of asylum services. Obviously, there have been some negative things last year, particularly with the warning notice that was after the sort of Daily Mail sting operation and people being struck off. So there was a thematic review in terms of asylum services. Now, don't switch off at this point if you don't do asylum, because there's something that I've been discussing a lot of my training events recently, and we'll come to that in a moment. So the review generally highlighted good practice, but it also pointed out some areas for improvement. It highlighted the lack of legal aid. But look at the first bullet point. WhatsApp was the preferred communication tool for clients for sharing information and evidence. However, few firms had formal policies in place to govern its use by fee earners. Now, whether you do asylum or you just do immigration, does your firm have a policy in place as to governing WhatsApp communications? Because often clients now want to send you evidence, they want to ask for advice by WhatsApp. Amy gives some helpful suggestions in the free advice note, and I'd encourage you to click on the link. And the SRA highlighted a good policy where somebody was using the desktop application from WhatsApp in order for it to be backed up on the client's on the firm's software into the client's file. So have you got, and I'm going to set you some homework as we go today, have you got a policy for governing how WhatsApp is dealt with in terms of client communication and sharing information and evidence? What about monitoring and supervision? Are you properly monitoring your fee earners, any consultants that you employ, supervising in terms of CPD and the like? That was something that was highlighted. And also being aware of reporting guidance. There may be a duty if you take on a case that has been mishandled by a previous firm to report that firm. So just make sure you're aware of that guidance. So I'd encourage you, if you're a fee earner, if you run an immigration department, to make sure you have a read of this. Even if you don't do asylum work, because there is some really helpful stuff, particularly in terms of that WhatsApp communication. Now, when I did the summer update for DG Legal, we spent some time looking at the changes to the family minimum income requirement and the move to 29,000. And at the time with the Conservative government, the proposal was to move to 38,700, and 29,000 was the first step. There was going to be an interim step and then reach the final step. Well, the Labour government has pressed the pause button. And actually, it's interesting when we're seeing the initial steps taken by the Labour government in terms of immigration. We've not seen anything radical at the moment, and we're seeing sort of cautious steps. What has happened is the Home Secretary has commissioned MAC to review, well, they're reviewing the IT and engineering sectors, but also they're going to review the minimum income requirement. So there will be no further changes to the minimum income requirement while the MAC review is being completed. Now, what I've done on this slide is set out the letter from the Home Secretary to Professor Brian Bell asking MAC to review the financial requirement. And as you'll see, the previous government set out its intention, 29,000, then 34,500, then 38,700. So there's a review commissioned and inviting recommendations from MAC within 9 months. So what can we do in terms of advising clients? I think in terms of advising clients going forward, we can say for 9 months, effectively from September 2024, there's unlikely to be any change to the financial requirements. So at least that helps clients plan in terms of preparing and making applications under Appendix FM. We can't say what will happen after that time. I think in the light of the very recent budget, I would be very surprised to see any drop below 29,000. Hopefully we won't see the planned increases that the Tory government planned come into effect, and it will stay at 29,000. But at least from now, while the MAC is reviewing it, there'll be no changes. So we have some certainty in order to advise clients going forward. There has been some updates in terms of the guidance for sponsors, in terms of workers. And there's updates on the 24th of October. I've put an extract from part 1, the apply for a license guidance. And that sets out the initial rollout phase of the new sponsorship service, Sponsor UK. It's going to replace the sponsor management system. At the moment, it's in an initial rollout phase and is only covering government authorized exchange sponsors, so-called PB1 sponsors. So just be aware of that. But this is the first steps in the rollout of the new Sponsor UK system. Just also be aware, for those of you who do sponsor license work and work with firms on their compliance, that there are changes also on the 24th of October to Appendix D, parts 1, 2, and 3 of the sponsor guidance. Because what we are seeing from the new government is a ramp up in enforcement activity in terms of illegal working, etc. So it's really important for those of you who advise licensed sponsors to making sure they're complying with their obligations. And when we come to some of the case law, we'll see the difficulties of challenging a revocation of a sponsor license. So there is a ramp up of enforcement activity under Labour. One of the big developments is visas. So all BRP holders are now able to create a UK VI account to access their e-visa. And again, some more homework for you. Make sure you're advising your client base of the need to create a UK VI account. And it may be a source of work for you as an immigration advisor to assist people in creating that account. This is from the media fact sheet provided from the Home Office, and you can use some of this on your own social media and websites to make sure you're publicizing it to your clients. Notice the second bit I've highlighted in this side, that BRP holders should keep their expired BRPs, as it may enable a more streamlined process for future applications to stay in the United Kingdom. So in the past, people had to send back their old BRPs. Now they're encouraged to keep hold of them because those chips can still be read and may be useful in the future for them. Remember that advising clients that creating a UK VI account enables them to access their e-visa, but it does not change their immigration status or their rights in the United Kingdom. So all BRP holders should take action now. Hopefully a lot of your clients have already done this, but make sure you're advising clients. And be aware of this. If client has indefinite leave to enter or indefinite leave to remain, and they currently use a different type of physical document, such as a wet ink stamp, a vignette sticker, they should make an NTL application to replace that. Now, this guidance, which was published in the summer, says replace it with a BRP. But as of the 31st of October, BRPs are no longer being issued. So if somebody needs to make an NTL application, they will then, if they're successful in the NTL application, be able to access an e-visa. So look, this is from the no time limit guidance, which is updated on the 31st of October. From 31st of October 2024, no time limit NTL applicants will be able to obtain an e-visa and will not be issued a biometric residence permit. Some other helpful guidance you want to be aware of as an immigration advisor and also to pass on to clients. There are reports of errors on e-visas. So the Home Office have created a link here where you can correct errors on your e-visa. So if there's an error in relation to name, sponsor reference, photo, NI number, immigration status, etc., you can correct those errors. There's a different way if you need to update your account if you've changed your details. But this is to report an error. If one of your client loses access to the phone or email that they use to recover their security codes and they can't access their UK VI account, here's a link in order to recover access to your UK VI account, which is important. And if your clients are planning to travel, they need to make sure their e-visa is correct, either before they travel out of the UK or if they're traveling with an e-visa into the UK. And here's the guidance, what they need to do in order to check their e-visa is correct. For those applying for entry clearance, have a look at this updated guidance on biometric information. It says this: e-visa overseas process. Individuals applying for entry clearance of over 6 months must, in most circumstances, enroll their biometric information and will be issued with an entry clearance vignette until early or mid 2025. They will be asked to create a UK VI account when they arrive in the UK in order to access their e-visa. So it looks like with entry clearance of over 6 months, they'll still get a vignette and then they'll have to create a UK VI account when they come to the United Kingdom. Just in terms of e-visas, a couple of other things I wanted to highlight: that children need separate accounts. It's one account per visa, and this can be set up and managed by parents, and it can be transferred then to the child when they're old enough to manage it. Again, if you're advising those who hold sponsor licenses, make sure their right to work check all their information is up to date, because they may have recorded 31st December 2024 because that was the date of the BRP, and they may need to do a new check. So just if you're advising licensed sponsors, make sure in terms of their right to work checks, everything's up to date, particularly because of the phasing out of BRPs. Now, I want to change the subject and have a look at practice and procedure, particularly focusing on the new practice direction for the first tier tribunal, which sort of dropped on us on the 1st of November of this year with very little guidance. I also want to cover the new guidance on taking evidence from witnesses abroad. Again, this is going to raise a lot of questions, and do sign up to one of my in-person events, my upcoming in-person event in London in December, where we can go through this in more detail. I've just tried to highlight some of the key things from the new practice direction. Notice 1.2, the parties must ensure they conduct proceedings with procedural rigor. The tribunal will not overlook breaches of the requirements of the procedure rules, practice directions, practice statements, and failures to comply with directions issued by the tribunal. So there's a real focus on compliance and procedural rigor. And really, they want to narrow down the issues in cases. So the disputed issues, paragraph 1.3, represent the parameters or scope of the appeal, and will operate as the foundation and structure for all judicial decisions. We're going to see in the end, there's sort of an encouragement for very much shorter judicial decisions, and in some cases, even oral decisions, not written decisions. So there's a real focus on the disputed issues. Now, when you're putting together your bundle, make sure your text size in your documents is no less than 12-point font with no less than 1.5 line spacing. That's important. 2.1 sets out the appeal process. You provide your notice of appeal. Most cases are lodged on the MyHMCTS system, where you don't need grounds of appeal. Just fill in the form there. The tribunal review validity and jurisdiction. Then the respondent provides their bundle. Then the appellant provides their bundle with their skeleton argument, and that's an important stage, and there's been changes there, so we're going to come to that in a moment. The respondent must provide their meaningful review, and there's some significant changes there in terms of the practice direction. There's then a hearing before the judge. A judge makes a decision, look at this, either at the hearing or in writing after the hearing, subject to Rule 29. And where relevant, an application for permission to appeal. Obviously, the initial application to permission to appeal to the upper tribunal is made to the first tier tribunal, and you make that on the MyHMCTS system. And again, they're talking here about sanctions for non-compliance, including the exclusion of evidence, and that's building from the reported upper tribunal case of Melechi. So you can see the direction of travel, procedural rigor, disputed issues, sanctions for non-compliance. And then there's in section 6, the practice direction in relation to interim hearings, what we've probably called CMRs in the past. The tribunal will hold an interim hearing whenever it considers necessary to do so in order to further the overriding objective. Such a hearing will be of great importance in identifying the disputed issues and ensuring that procedural rigor is observed. There it is again. Parties or their representatives are expected to attend these hearings. So if the case is listed for an interim hearing, make sure solicitor or counsel attends that hearing and properly is aware of the issues in the case. Why might they order an interim hearing? Well, it may be for the purpose of identifying or narrowing the issue and the issues and the evidence needed, dealing with preliminary issues, if either party has made an application to decide those, giving or overseeing compliance and case management directions, deciding the mode of hearing, where there needs to be a final hearing fixed, or any other matter. And remember, at an interim hearing, a judge may make a decision which finally disposes of proceedings. What you will get at the end of a hearing is an order, and that will give written confirmation of all relevant decision-making and directions as set out in paragraph 6.1 above, and also any issues that have been agreed at an interim hearing as being relevant to the appeal, and any concessions made by a party. So if you're preparing for an appeal, check if there's been an interim hearing and look at any orders that were made, identifying and narrowing the issues. Bundles. This is really important. Look at 7.1. Again, bundles need to be prepared with the disputed issues in mind. Representatives must be prepared, final sentence of 7.1, to justify the inclusion of all materials in the bundle and to explain how they relate to the disputed issues. So I can see here the tribunal and legal officers rejecting bundles where there's sort of material included in it which doesn't relate to the disputed issues in the case. 7.2. Any bundle prepared by a legal representative and the respondent must be in a digital, indexed, bookmarked, and paginated format, where every page is A4, and documents must have optical character recognition, unless doing so garbles the text. Now, I've talked about this previously. If you go and watch my DG Legal Summer webinar, when we looked at the section on upper tribunal bundles, we discussed this. I've done a video in terms of upper tribunals, but we discussed optical character recognition, indexing, and bookmarking. I still see bundles. In fact, I was working on one yesterday where a statement from an appellant had been literally a photograph taken of the statement. That's not going to be optical character recognition. That wouldn't comply. In the previous DG webinar I did, I suggested some software you could use, some PDF software, some free software. I've also posted those on social media and on my Telegram channel. Make sure your caseworkers are familiar with the relevant PDF software so you can produce these compliant bundles. So some homework for you as a team is to make sure you've got and you're using PDF software so you can produce bundles in this format, and from now on making sure all your bundles are in this proper format. Skeleton arguments, ASA. Again, 3 sections they should be in, and this is the structure you should use. Have 3 S's: summary, schedule of the issues, submissions. So there's your structure. Should be no more than 12 pages of numbered paragraphs. If it is more than 12 pages, you must make an application to rely on it, 7.7. What about your bundle, 7.9? The bundle should include any additional evidence or material which is not included in the respondent's bundle. This applies even where no respondent's bundle has been provided. Any evidence must be relevant to the disputed issues. So don't in your bundle, I still see it, loads of documents which are in the respondent's bundle, just repeated in the appellant's bundle. You'll get that bundle rejected, and then make sure it relates to the disputed issues. If an issue has been conceded, say in an entry clearance application, say finances are conceded, you won't need to put all that financial documents in unless they're relevant to an ongoing disputed issue in the case. What about the respondent's review? This is welcome. The respondent must provide a review within 14 days of the bundle and the ASA. It mustn't exceed 6 pages unless they apply for permission. This is important. It mustn't contain standard or pro forma paragraphs. The respondent has got to set out whether she agrees or not with the issues as set out in the ASA and whether there are additional issues. The respondent should make submissions on those issues and whether she agrees with the appellant's position on those issues. E is helpful. Again, it's narrowing down those hearings to specify which, if any, witnesses the respondent intends to cross-examine. But if the respondent does not intend to cross-examine a witness, the respondent must set out any objections to that witness statement being read by the judge. And if a witness provides a further statement, they should attend the hearing to give oral evidence unless the tribunal otherwise direct. Address whether the appeal should be allowed on any ground if the appellant and or their key witnesses are found to be credible to the applicable standard of proof. Identify if the respondent is withdrawing any part of the decision. Can the appeal be resolved by the hearing, and the name of the author of the review must be put on the review. So that's helpful in getting a more meaningful and focused review from the Secretary of State, even addressing which witnesses they want to cross-examine. If you provide further evidence, 7.13, after the review, you've got to include an explanation why it was not provided earlier. So if the Secretary of State has raised something in the review and then you need to provide further evidence to deal with that, you'll need to provide that explanation when providing it. You need to provide it in a bundle. Don't do a new bundle which contains everything plus the new material, because that's already there. And it says don't reproduce any evidence that has already been filed unless you're asked to specifically do so. And it tells you how to name your second bundle at 7.13. Now, witness statements. Again, we've talked about this previously, because witness statements need to be capable of standing as the totality of the evidence of in chief of the person giving that statement. So good witness statements are essential. And if there's been developments, 8.3, do a supplementary statement. Obviously, if it's after the review, ask for permission to put that in if there's been sort of developments. 8.4, there's a slight change. In terms of asking questions in chief, there now needs to be shown a good reason. It's not exceptionality anymore. There's a good reason, but you must have permission from a judge. So I think if you're preparing a case, don't think, oh, well, Adam can ask some questions in chief. Think, well, I want this witness statement to stand as the totality, because only with good reason and permission is Adam going to be able to ask questions in chief. Now, in terms of the body of the witness statement, the next paragraphs set out what witness statements should contain. So some homework for you. Do your witness statements routinely, are they set out in accordance with 8.5 and following? Make sure they do. Now, statement of truth and interpreter attestation. Again, you may need to change some of your precedents to make sure they comply with this. 8.10, a witness statement is the equivalent of the oral evidence which that witness would, if called, give in evidence. It must include a statement by the intended witness in their own language that they believe the facts in it are true. So it seems that the statement of truth needs to be in the original language from 8.10. I'm open for discussion on this, so come back to me, not today, but do feel free to come back to me on that. But that was my reading of 8.10. The statement of truth is set out at 8.11. And then helpfully 8.12, we've previously discussed on the previous version of the practice statement, whether you had to have an original version in the appellant's language and then a translated English version, which would cost a huge amount and be very difficult. That's been abandoned now, because 8.12 says if the witness statement is in English and the witness does not understand English, the witness and interpreter must endorse the following attestations. The statement has been read to me in a language I understand, by name of interpreter. I, name of interpreter, read this statement to name of witness, faithfully interpreted into language. So please make sure your statement of truth is in the form set out in 8.11, and you've got the necessary attestations in the form of 8.12. Let's move to expert reports. Those experts you instruct, make sure they're aware of part 9 of the practice directions. I posted on LinkedIn, on another socials, I think early this week or maybe last week, saying, make sure your experts are aware of part 9 and include part 9 in your standard letter of instruction to experts. So again, some homework, your standard letter of instruction to experts, make sure it embodies Part 9. I haven't included 9.3, which contains a helpful list of things that expert reports must contain. The thing to be aware of is the tribunal don't want lengthy and discursive commentary, which is not directly relevant to the disputed issues and is not conducive to the proportionate dispatch of judicial business. We've all seen over the years very, very, very long expert reports with lots of sort of cut and paste guff in it. That's what they're trying to get rid of. So they're saying an expert report must not exceed 20 pages, but you can apply for in writing if the expert report exceeds 20 pages or for any addendum reports to be served. And I've had solicitors come back to me because a lot of good expert reports do exceed 20 pages. But again, they must be focused and directly relevant. Make sure your expert is complying with Part 9. Make sure they use the correct statement of truth as in 9.4. Again, country background information. 10.5, if you're trying to rely on country background information that is not available in the relevant country guidance, you must make this clear and what disputed issue it goes to. And then you must include a country information schedule within the bundle, which refers to either the paragraph of the country guidance or the extracts from additional country information. It mustn't exceed 12 pages, and it can include, which is helpful, the hyperlink to the source document. And if either party wants to challenge and see the full source document, they need to raise that within the ASA or the review 10.7. Again, if you need to be more than 12 pages, rely on it. You need to make an application if your schedule is going to exceed 12 pages, 10.8. Actually, what I've included at the bottom of the next slide is a link to EIN for the EIN citation tool, which you can create really helpfully on EIN, a country information evidence schedule. So again, if your firm's not a subscriber to EIN, that's a fantastic resource. Just finally on this slide, section 15, about written reasons should only be provided where they're expressly required by the procedure rules or with the interests of justice, otherwise compel written reasons being given, and in every case where they're required, only to the extent and in the terms necessary to dispose justly of the matter in hand. In some non-deportation Article 8 human rights and EUSS cases, the tribunal may be able to give its decision shortly after the conclusion of a hearing by providing a short notice of decision or by stating its reasons orally. Reasons will only be provided orally where the judge is satisfied that the audio recording facilities are available and an audio recording will be made of the oral reasons so that the audio recording and any available transcription can serve as a starting point in drafting any written reasons if requested. Let me just give you a reference point. Look at section 29.3 of the first tier tribunal procedure rules in relation to cases where written reasons must be provided and other matters where there's not written reasons. So have a look at section 29.3 of the first tier procedure rules. Let's look at witnesses giving evidence from abroad. So this is the presidential guidance note number 2 of 2024, taking evidence from abroad. I appreciate there probably is loads of questions from the last section I did on the new practice direction. Happy to discuss those with people offline if you need to contact me, or please just come to my in-person event where we can have a bit more discussion and work through these together, because I think it raises some really significant issues. But if you're going to rely on live oral evidence by video from abroad, you've got to get permission from the tribunal, even if there's no diplomatic or legal objection from the country in question. And even when there is permission, the tribunal will need to still consider their discretion and consider the overriding objective. Paragraph 5. You don't need permission where somebody's giving evidence by video within the United Kingdom or one of the Crown territories. This doesn't relate to producing a written witness statement or documentary evidence, and it doesn't affect claims certified under 94B. Now, the starting point is the FCDO website, and it lists there where countries have responded and what their response is. If a country has expressly refused permission, there's no point in asking, because all evidence cannot be taken in that case from that country. In other cases, if you wish to rely on oral evidence from abroad, you need to make an application to the tribunal. Paragraph 12, on notice to the respondent. Paragraph 12 sets out what you need to include in your application. In their review, the respondent must say, is the evidence in dispute and is cross-examination necessary? Because if not, the tribunal will determine that the witness statement can be read and there is no need for video evidence from abroad. And if the respondent doesn't respond to this, the tribunal will assume that they don't dispute. Where the evidence is disputed, well, if it's a consenting country, the tribunal may grant permission. If it's a country where there's been no response to the FCDO or individual permission is required, the tribunal will direct that you make an inquiry with the taking of evidence abroad unit, and you have to pay an additional fee. There'll be 6 weeks then given to the foreign embassy to respond to the taking of evidence unit. If they refuse, the tribunal will refuse permission. If permission is granted or in part, the tribunal then may give permission. If more information is required, the tribunal will consider whether it's appropriate to give more time, paragraph 23. If there's no response, the tribunal will proceed on the basis that it cannot be satisfied that permission has been given and refuse to admit it. In terms of practical arrangements, that's on the appellant, paragraph 26, and you need to ensure that approved video platforms for taking oral evidence can be used, paragraph 27. If you're a visitor resident in another country, you still need permission, even if it's a British citizen on holiday there. So consider paragraph 29. In those circumstances, is it better to postpone the hearing and list it on a day when the witness can be present in the United Kingdom, paragraph 29. In any event, the tribunal must consider delay and the overriding objective in all cases in terms of giving permission. So just be aware of that. Now, I'm conscious we've got 15 minutes left and there is a lot to cover. So let's give you some highlights from the statement of changes. So this is the Labour Party's first statement of changes, HC 217 from the 10th of September this year. There's an introduction of a visa requirement on Jordan. There's the implementation of the electronic travel authorization. So again, we talked about e-visas. ETA obviously applies to non-visa nationals. It's in force for the Gulf states. This month, November 2024, it'll open to all nationals traveling to the UK who do not currently need a visa, except Europeans, and will be a requirement from the 8th of January. In March 2025, it's extended then to European nationals, and therefore it'll be a requirement for everybody from the 2nd of April 2025. So again, something to make your clients aware of in terms of non-visa nationals is, do they need an ETA? Can you as a representative help them with an electronic travel authorization application? Some headlines from the statement of changes. There was the end of the diplomatic visa waiver and introduction of a diplomatic visa arrangement, introduction of a VIP delegate list, some changes to the Appendix Bereaved Partner and Appendix Gurkha in terms of fee waivers for destitution, changes to the EUSS, include referring to the scope to automatically convert pre-settled status under the EUSS to settled status, where the person qualifies without them needing to make a further valid application, and to require a joining family member to apply to the EUSS within 3 months of their first, not latest, arrival in the UK since the end of the transitional period. Here's the dates for the changes. I've just set that out for you there. Now, In my longer in-person seminars, I spend some time going through Appendix Long Residence, which needs to be read alongside Appendix Continuous Residence. Continuous residence covers absences from the UK. Now, the new provision in relation to absences is 180 days in any 1 year, but there are transitional provisions. And CR 2.2a has been amended to give clarity for the transitional arrangements for applicants applying under Appendix Long Residence. So from the 8th of the 10th, the 8th of October, here's what CR 2.2a says. Subject to CR 2.3, where the application is under Appendix Long Resident, the applicant must not have spent a total of more than 548 days outside the UK during their qualifying period, where that 548-day total was reached before the 11th of April, and must not have been outside the UK for more than 184 days at any one time during their qualifying period, where that absence started before the 11th of April 2024. So just be aware of these transitional provisions in terms of absences when the absences were before the 11th of April 2024. Here's an article from LexisNexis News on, again, some changes in HC 217 in terms of the going salary rates, because there were the changes in HC 590, but they contain some drafting errors. And we had on the 10th of July, the Home Office revising the guidance, changing some of the going rates. And now there's been further clarification and amendments in the statement of changes HC 217. So make sure those of you who are making applications for skilled workers, etc., and relying on Table 1 and Table 2, you're relying on the correct going rates. And this article from LexisNexis is helpful in relation to that. Finally, then, we've got 10 minutes left. Let's do some case law. Again, I'm just going to give you some headlines in terms of case law and cover a wide range of topics. Big case law from the Supreme Court on Section 55, Best Interests of Children, and Article 8 is the case of CAO, a Northern Irish case. The Supreme Court disagreeing with the approach of the former president of the tribunal, now Lord Justice McCluskey. In this case, the tribunal itself, the first tier, had looked at Article 8, and in doing so had taken the best interests of the respondent's daughter, so who was the appellant before the tribunal, as a primary consideration. What the Supreme Court said is, well, in an appeal to the FTT, they look at the matter afresh and make its own decision. They're the primary decision maker. In terms of the best interest, in general, the tribunal doesn't have to conduct its own inquiries, but there may be cases where no attempt has been made to consider the best interest of children, where they need to do that. Look at paragraphs 47 to 48 of the judgment. In terms of the FTT, the basis for its decision in terms of best interest is Article 8, not Section 55. It's under Article 8 that the best interest of a child is treated as a primary consideration. The Section 55 duty is imposed on the Secretary of State, and in particular Section 55(3), which is about referring to the guidance, is imposed on the Secretary of State. And in an appeal, it's not there to discipline the Secretary of State for failure to comply with the guidance, although if they don't properly assess the best interest, they could result in losing the appeal. In a JR case, although they may be ordered to properly fulfill their duty under Section 55(3). What the Supreme Court finds is that the Scottish, English and Welsh cases are to be preferred over the Northern Irish cases, and that line of authority from McCluskey, where he was finding that there needed to be express reference to the statutory guidance. What matters, the Supreme Court says, is that in substance the guidance has been complied with, although express reference to the guidance would be best practice. So have a look at that if you're dealing with best interests. I've set out one slide with key aspects of the judgment. I don't propose to go through it in this webinar in more detail, but it doesn't water down the obligation in terms of the FTT to look at the best interests of children. Don't put grounds of appealing saying, well, the judge hasn't mentioned Section 55, because the Section 55 obligation is on the Secretary of State. It's in Article 8 terms, the tribunal must consider the best interest as a primary consideration. EUSS case law. EUSS always makes our head hurt, so let's briefly look at a few cases. VASA, I may have touched upon in the summer. That's those extended family members admitted with those odd immigration officer stamps in their passports. In Alaraj, they found that in the tribunal, they found that those stamps were of no legal effect because they weren't a relevant document for the purposes of Appendix EU, and they weren't facilitation of admission for the purposes of the withdrawal agreement. The Court of Appeal in VASA agreed they weren't documents for the purpose of Appendix EU, but did find the decision breached the withdrawal agreement because they were admitted with those stamps. I won't say any more of that because it'd be limited class of people that's relevant to. Rexage is to do with assumed dependency, those parents who initially entered on assumed dependency, whether they could rely on the assumed dependency then when applying for pre-settled status. The upper tribunal said they could. The Court of Appeal disagreed and said, no, they had to show dependency. And I think the rules had been amended by that time in any event to say they did need to show dependency. This is an order from an unreported JR, and there's a link to a helpful article by Adrian Berry on the Home Office pausing EUSS applications where there was a pending prosecution, and their guidance was ruled unlawful. In response to this judgment, they've now updated the EU settlement scheme suitability requirements, and it's helpful. It says this: the fact that an applicant has a pending prosecution does not prevent caseworkers from progressing the application as set out above. If the applicant satisfies the eligibility criteria and suitability criteria, setting aside the allegations, which is the subject of the pending prosecution, leave may be granted. If the applicant does not satisfy the eligibility criteria and the suitability criteria, setting aside the allegations which are the subject of the pending prosecution, leave should be refused. If the applicant is subsequently convicted and given a custodial sentence, the case will be referred through the usual prison referral mechanism. And if deportation is pursued, that will invalidate any EUSS leave. So hopefully those who were in limbo for years, especially with the delays in the criminal justice system, their cases under the EUSS now should be processed, even though they've got those pending prosecutions. Masiri is a helpful case. This is the Zambrano case where the Home Office were being cheeky after Akinsanya and saying, well, there's a realistic prospect of you being granted leave under Appendix FM, so you're not a Zambrano carer. That policy was found to be unlawful. Appendix EU said you're not a Zambrano carer if you have leave under another part of the rules. It's not incumbent on a decision maker to consider, is there a realistic prospect of you being granted under Appendix FM? Just some final headlines. Deportation case law. Vargova deals with post 31st December 2020 criminality, and the stage 1 decision and the stage 2 decision, which deals with human rights. If you're dealing with a stage 1 or a stage 2 and the different focuses of each decision, have a look at Vargova. SM is a recent decision on revocation of protection status appeals post-Brexit. And it's a very clear guidance in relation to that and the ESSA principles, and where leave is revoked only with reference to Section 72. And if you haven't rebutted the presumption, Section 72.10 saying the appeal should be dismissed. But there may be cases where at the same time there's a decision to cease or exclude you from convention refugee status, and the tribunal should still make certain findings as to whether you're a convention refugee. Paragraph 6, again, have a look at that. Sponsor license revocation, and I've got 4 minutes left. Well, in the last webinar, I looked at whether there was a need for this global assessment on the wider impact of revocation, such as the impact on the industry. Supporting care had been in favour of that, but they hadn't considered the decision in Prestwick. There had been, following that, New Hope and One Trees Estates, which found there was no need for this wider assessment and investigation on the impact of revocation on the industry. New Hope actually was a positive JR, where it was successful in terms of the sponsor license challenge because the claimant hadn't been given a proper opportunity to respond to the Home Office. There's been a recent decision called Tender Care Management. Here's the EIN summary. There was a number of bases for revocation. Some were mandatory, some were discretionary, but where there's a mandatory breach, there is no need for the Secretary of State to go on and consider her discretion. This was in relation effectively to somebody acting as a care agency and providing workers for other organisations. And they go through the guidance in tender care, and an employment agency can't sponsor a worker. It's not permissible to sponsor a worker for an ongoing routine role, nor to provide an ongoing routine service for a third party, regardless of the nature of the length of any arrangement. I've set out here the sort of principles the court will approach a sponsor license revocation challenge, because obviously the court will operate a limited role and it's very difficult. And this case, particularly with the mandatory challenge, found, well, there was no discretion. So if your client commits a breach of their sponsor license, which is a mandatory ground for revocation, it's going to be very difficult to challenge. Now, as I said at the start, Labour increasing enforcement activity. So if you work with licensed sponsors, help them by providing mock audits, check their compliance as firms of solicitors. That's something really to be focusing on. Two cases on judicial fairness. Hossain was a TOEIC case. The questions asked by the judge were not considered unfair. Second unfairness was HEMA, a marriage of convenience, where the judge was considered to have acted unfairly. A fairness challenge is an objective assessment, and counsel needs to raise the unfairness at the hearing. If you're challenging a case on unfairness, have a look at these cases, because it is very much specific to the individual case, but these cases set out the principles. Some recent case law on good character requirement and looking at slayman and whether something is material. So do have a look at that if you're challenging deprivation decision. Entry clearance in Article 8, Al Hassan is very helpful in clarifying the decision in KF and the importance of looking at the family as a whole in assessing proportionality in an entry clearance case. So if you're arguing entry clearance in Article 8, KF's are really a helpful case law. EULA's helpful in relation to new matters. If you raise something, obviously, in an application and the Secretary of State is silent on it, they're taken to have considered it and it's not a new matter. GADM gives some guidance on judicial review and when there's a duty on a decision maker to make further inquiries in Section 31(2)(a) of the Senior Courts Act, and whether relief is likely to be refused because the outcome is substantially likely to be the same. And just finally, I've set out an unreported case on non-Afghan nationals being granted ILR under the Afghan resettlement scheme, principally because it contains some really helpful guidance on the interpretation of policy when you're doing a JR on the basis of a policy challenge. It's 2:00 on the dot. I'm sorry to have to rush through so much, but hopefully there's been something for everyone in the webinar. Thank you so much for DG for putting this on. They'll get you the slides. Do give us some feedback of what webinars we can offer next year, but thank you so much. Back to you, David.
Yeah, thank you for your excellent presentation, Adam. And yes, just to reiterate, the slides and the recording will be sent over tomorrow. And as usual, you will receive an email asking you to rate the webinar out of 5 stars. So if you enjoyed it, please do rate us and leave feedback and any suggestions for future topics. Now, we are taking a break until the new year when we shall continue with our free webinar series. However, we do have a very busy period ahead of us this month and next month with very low-cost training. We're producing 16 low-cost courses from as little as £39, which covers areas such as AML for fee earners, AML for support staff, Lexcel, the COFA role, the accounts rules, supervision, safeguarding, equality, diversity and inclusion, and of course exam preparation for the immigration and asylum accreditation scheme. Anyway, thank you very much for watching, and we all wish you a very pleasant afternoon. So thanks again. Bye for now.